In this video, we're going to talk about if a revocable living trust or a living trust can help someone in Florida qualify for Medicaid after 5 years or provide any kind of asset protection. We get this question a lot because a trust sounds like it provides asset protection, but the reality is there are many different types of trusts in this world, and a revocable trust or a living trust or a revocable living trust does absolutely nothing to protect someone's assets when determining whether or not they are eligible or not eligible for Medicaid, or by the way, provide any level of asset protection for the people who created the trust. And the reason why is a revocable living trust is essentially, for all intents and purposes, it's a pass-through entity, right? Generally, when you create a revocable living trust, or if your parents have created a revocable living trust and they put their house in the trust, they can put their bank accounts in the trust, they are not only the creators of the trust, they are in control of the trust because they're generally the trustees. And even if they aren't the trustees, they're the beneficiaries of the trust. That's what makes it a revocable living trust. It provides you a way to control your assets while you're alive, and it does a very good job of allowing your heirs to avoid probate after you pass away, or if you become incompetent, it allows those who you designate to still manage your life and manage your assets on your behalf, but it's still on your behalf. And so as a result, when we're talking about Medicaid planning, right, which is typically we're talking about getting assets out of our clients' names in a Medicaid compliant way, in a way that's not construed to be a gift, in order to legally and ethically qualify my client for help paying for home health care, ALF care, or nursing home care. Sadly, a revocable trust doesn't do anything for us. It doesn't hurt or help. So for example, a home that's in a revocable trust is protected from Medicaid, not because it's in a trust, but because homesteads are protected anyway for Medicaid purposes. So when a client comes to me and they say, well, I only have a couple $1,000s in my name and everything else is in my revocable living trust, I have to be the bearer of bad news and explain, well, that's as if it were in your name anyway, and we still have to engage in alternative Medicaid planning strategies. Fortunately, there's lots of stuff we can do. Most of my clients come to me throughout the state of Florida who have too much by way of assets, whether it's in their individual name or whether it's in the name of their revocable trust or revocable living trust. And we still have some wonderfully advantageous tools that we can use to legally and ethically protect their assets. They don't have to wait 5 years. In fact, we can maneuver within a matter of weeks or months and get them financially eligible for Medicaid, again, in a long-term care context, to pay for nursing homes, help pay for an assisted living facility or some home care as well. So if you're interested in learning more about estate planning, we may talk about revocable trusts, right? Because again, avoiding probate, they have a role to play, and they can be very useful tools. Or Medicaid planning, where we're not going to be so focused on a revocable trust. There are other types of trusts and other tools that we might use. If you're anywhere in the state of Florida interested in learning more about estate planning or Medicaid planning, we could certainly help with probate and probate avoidance as well. Please give us a call, set up a consultation. Thank you very much for watching.